Hello and good morning. Welcome to this webinar. It was supposed to start at 11. We are not that late. My name is Dominica Wairumu. I'm a SOC analyst at Bridges. On top of which I do incident response, vulnerability management. As I said, welcome to this webinar. We have our guest speakers or our panelists today. There's Abigail, there's Rufaro, and there's Quincy. I'll let them introduce themselves. We'll start with Abigail.
Okay. Good morning, good afternoon, from wherever you're joining from. Thank you for joining this session. My name is Abigail Sami Wambua. Currently, I am a data privacy advisor working with Plan International. My work revolves around data privacy management and advising in the humanitarian context. I have been in the privacy space for a few years now. Before that, I was working, doing a lot of trainings, working with a law firm. And so I'm quite excited to share with what I know about the new tech, AI, emerging trends in biometrics, and also to learn from my fellow panelists and the people who have joined, everybody else. Thank you so much.
Thank you so much, Abigail. We are also eager to learn from you. Rufaro?
Good morning, everyone. Thank you for having me. I'm the managing partner of Aramando Attorneys. We established some time back in 2022. I've been in private practice for a long time, and I also have experience from the public sector. I used to be a prosecutor there for almost 8 years. And so my experience spans over 16 years experience of litigation. I also hold a master's in cyber law, and I enjoy all conversations, data privacy. I do consultancy on SAME, and I also assisted in the review of our current law, the Cyber and Data Protection Act, which was enacted in 2021. So I was part of the team that did the review on the then bill. So yeah, this conversation comes at an apt time when everybody's talking about artificial intelligence. So I'm excited about the conversation that we're about to have today. Thank you.
Thank you so much, Rufaro. We'll have our final panelist, who is Quincy.
Good morning. My name is Quincy Otieno. I'm a lawyer in Kenya, particularly I'm a lawyer at Parliament of Kenya. Good Lord, Rufo has such a big accolade stamp that makes me say mine like a walk in the park. So I am a legislative drafter within the parliamentary chambers. And then I do teach and train and do consultancies on AI safety, governance, and alignment. There are 3 different distinct fields. However, I do have the expertise to train organizations, and particularly within the finance and education sector. Additionally, I do specialize within ICT law, particularly when it comes to SAS, IAS, and PAS contracts. Additionally, I'm doing my PhD in biometric systems, so this will be interesting. We'll compare if my findings are actually rich enough to be involved in the discussion. Thank you.
Thank you so much for that warm introduction. From my understanding, this conversation will be an informative one, since the panelists have the knowledge that is needed to talk about these topics. Well, we'll dive into a conversation. For our audience, feel free to raise your hand to answer questions here and there, to ask questions as we go. So we'll start with understanding the AI and biometrics technology. Then we'll go to identifying the risk or the risk check that are related or associated with these two technologies. From there, we'll go to mitigation. Here's where we'll give things or what organizations should deploy in their workplace. Then finally, we'll dive into the latest trends, compliance that is in relation to these two fields. Okay. Well, I do not want this session to be a Q&A, so make sure in case you have a question, just raise your hand, make contributions. Yes. So as we said, Rufaro said that AI is one of the emerging trends, or it's here with us. Now, what kind of privacy concerns do you think raise most red flags in relations to GDPR? I'll start with Rufaro.
Okay, so AI systems, they pose a lot of concerns and significant risks through collection of sensitive personal data. And in this instance, we're talking about biometric information. And the major privacy concerns include unauthorized data usage, algorithmic bias, surveillance, overreach, and data breaches that can actually face users across the world. And you find that these concerns cut across jurisdictions. It's happening. It's a world phenomenon, if I can put it like that. And then when we then draw down to the GDPR and other legislations within the African context as well, you will see that there's been an address of privacy issues that would assist us to address these privacy concerns. So one of the issues that even the GDPR raises is implementation of privacy by design principles. And you'll find this in the GDPR itself. It actually addresses privacy by design. And it is something that can assist us in these major privacy concerns that are raised by artificial intelligence and in the context of biometric information that can be collected by the use of artificial intelligence systems. So in that context, we have examples that have happened before. In California, a surgical patient discovered that her medical photographs had been incorporated into an AI training data set. And despite her having consented only to the covering of the clinical use of the images. So this is one of the risks that comes with artificial intelligence being used insofar as biometric data is concerned. Sorry, you're muted, Dominica.
Sorry for that. Thank you, Rufaro. You've talked of a very interesting and a strong point on AI and data, which is consent. Before we go to the next point of discussion, or before we expound further, I would like Abigail and later Quincy to give their contribution on the risk associated with these technologies.
Okay. I think so. When I'm thinking of privacy risks associated with AI and biometrics, I think also the first thing we'd like to do is just identify exactly what these risks are and what risk means in simple language. Risk just means the chances of something going wrong. And in a privacy context, we're looking at what could go wrong and what is privacy all about. It's protecting the rights and freedoms of data subjects. And so where you find that data subjects are not able then to exercise their rights, whether it's the right to access, whether it's the right to information, the right to deletion, to not be subject to automated processing, then where there's a risk that they might not be able to exercise those rights, then those are some of the privacy risks we are talking about. And when you look at AI and how much, for example, how much data it needs, and the types of AI, if you're looking at supervised and unsupervised, and reinforcement AI learning types, right? So machine learning in that sense means this AI can be supervised, meaning it has been given titles and subjects, and it can name it. How it comes up with its solution is by the titles it's been given, by the category it's been given. And supervised means it is free to do as it pleases. And then with reinforcement means for whatever decision it makes is a reinforcement learning. Now, all those kinds of AI, they usually need a lot of data to come up with, whether it's predict something or to generate something. Now, all that data that is being collected then ends up what can end up happening is data subjects lose control over their data, and so then they're not able to exercise their right. If you are not able to control your data, you don't have access to your data, you're not able to know who has your data, then in that sense you're not able to exercise your rights. And so when I'm looking at the AI risks, it's looking at and biometrics as well, because of how sensitive it is. It's looking at how AI works, how much data it collects, who is controlling it, at the speed it's growing at this point. Then how are we still able to protect the data subjects and ensure that they are able to exercise their rights? And even under the GDPR, the key risks from AI stem from, for example, the principles of processing, which is just ideally just the rules that GDPR has given you around processing personal data, excessive data collection, function creep. Now, with all that data that's been collected, we end up having function creep. We talk about data minimization as well. Using data for unintended purposes. If you had collected this data to train a model and it was specific for this data, and then you decide you want to use for another purpose because of all the data it's collecting, in that case, then now we are going beyond. We're moving away from being able to for the data subjects to exercise their rights. We are now going into the violation space. Again, with lack of transparency, some AI models are not transparent on how they use this, on how they what personal data they collect, how they will use it. And then also for training models, like for example, ChatGPT gives you the option: do you want to have your information or the personal data that you've been inputting to be used for training models? Some models that you come across don't have that option, and so I think some of those are some of the risks that we can look at stemming from GDPR.
Thank you, Abigail. I'll give these points.
Thank you very much. So I've learned a lot from Abigail, especially on the principles and the opt-out rule. During my research, the one thing that I picked is majority of AI decisions or AI risks when it comes to privacy always relate to automated individual processing by autonomous systems or by ADM systems. Once we define ADM systems profiling as a privacy risk and bias, once we establish that indeed it is found in privacy legislation, then we can go ahead and now start looking at it. However, there's a limitation to it. So mainly for biometric data, we have, particularly within the GDPR, so Article 9, which categorizes biometric data as a special category and is prohibited unless there's explicit consent. So consent is one of the legal bases that has to be there for it to be validly collected. If I look at GDPR as a whole, we have a lot when it comes to their Article 22 on automated decision-making systems or profiling. It mirrors Section 35 of the Kenya Data Protection Act. A lot of things when it comes to privacy risks, particularly within the biometric sphere, is down to the algorithmic bias. And like I said, we have to link profiling and bias together for it to fit the bill. Because don't forget, even if you conduct a DPIA on an AI system, you still have to find out what does the algorithm entail to do or is coded to do according to the library notes. A lot of it is down to the risk, particularly that connotes processing this particular data. And you can see this when Kenya, we had the WorldCoin case, but the court didn't really question the shortcomings of it just of the DPC conducting a DPIA, particularly when it comes to a high-risk system. And it only answered two questions within that decision, which was mainly on the DPIA compliance and on the token compensation, which was done to that platform. The moment we have a strong technical and organizational safeguards when it comes to now the processing in itself, then we cannot talk about the data, because we can talk about reinforcement learning and the training scope creep of majority of automated machines, but there are also safeguards, which I believe we'll granulate and talk about it during the talk. A huge part of privacy within the automated space is usually down to how many regulations or how many checks and balances are there at different stages. Because for the data protection sphere, the data sphere, there is a lot of legislation and regulation which is already established. However, it is limited to the application of AI systems, plainly because at some point, as Samia said, they have the black box theory, which if you read the Black Box Open Society academic paper, you will observe even those who code the particular AI systems or AI agents will tell you that if it's not a direct decision tree, you will reach a point where you cannot explain the next step or the next level of processing. And you can see this in State versus Loomis as a case, which basically talks about the right to violation of someone's right to opt out, which is now etched in data privacy legislation. It's all about linking. Like we could state the articles in the GDPR, within the Kenya Data Protection Act, BOIPA, the Ghana Data Protection Rules, the Nigerian NGPCD or CPD, and you will find that if you don't bring out profiling as a method of bias within the systems, then you cannot bring out the privacy risk aspect of it. And this is just from a bit of research, but we'll get to break it down in our talk. Thank you.
Thank you so much, Quincy. Both your points and Abigail's shape or lead us to the next topic or the next question that we'll answer. Abigail, you've talked so much on GDPR principles. You've talked of automation of data, data minimization. You've talked of consent. Now, the topics on themselves, the theoretical part of it is very easy to understand. But now, since you're on the field, how hard is it to apply these principles in relation to biometrics and AI?
How hard is it to apply them on the field? I'll speak for my experience. Two things. Number one, just because of how AI is growing, how fast it's growing, how fast it's changing, it's difficult to keep up. It's difficult to keep up. And then it's also difficult to control. So I think one of the things that we've seen, for example, in the organization, is trying to put guardrails of how people use AI within the organization. What happens is we end up having, like, if we're talking about the principles, data minimization, you find that even with the tools that they'd use, they just want to put as much data as they can, because to see what they can get out of it. What you find happening is that you're unable to control what people are using. You may put guardrails, you may put policies, but because of the speed that this AI is moving in its growth, the amount of data that you can get out of it just by how much you put into it. Again, there's a saying that goes around, and I think you could correct me if I'm wrong, but they say AI thrives on big data, a lot of data. And so that being said, then it becomes very difficult as well to control and manage personal data in terms of the GDPR principles, especially for data minimization. The other thing I think I also wanted to mention was the purpose limitation, because of the amount of data you would put in. For example, you find that if you're training a model, you're collecting a lot of data, and then what happens after that is you find this data, you want to use it for something else. Just because you've collected that amount of data, it requires a lot more strength and strongholds to ensure that you stick within the principles of data minimization, of purpose limitation. The other one is also to talk about explainability, which is when we talk about transparency. One of the big things that we talk about AI, and I think Rufai will talk about this, is the explainability of AI. Can you explain how it got to those decisions? That then ties into the principle of transparency and accountability, so that you're able to explain to the data subjects, and you're able to explain to them how this particular decision was made, how their personal data is being used when it comes to training in the AI models. Now, a lot of the times, if people are not that well versed about these things, even within the organization, if our knowledge on AI is limited, then it becomes difficult to enforce and work with these principles that have been put in place already by the GDPR. Yeah, I think Rufai, you can add.
Yes, thank you, Abigail, for that. It's very interesting when we talk about the training data in the context of the principles of data minimization and the purpose limitation, because we've seen how there's been manipulation of AI systems recently. There was a study that was being done by a gentleman, a professor from America. I've forgotten his name, I'm sorry. But he was talking about how there's been an evolution. I'll put it in quotes. I'm sorry, I cannot put my camera on because I'm having instability in my network. So I realized maybe if I switch it off. So he was saying that there's been an experiment that was being done where the artificial intelligence system, the model, was being asked a question, what it will do, can it eradicate the human race? If it notices, I know, right? Can it eradicate the human race if it notices that the human race has become a danger unto itself, and it has become a danger to the environment and to data protection? It was a whole lot of things. And the response was yes, and it said a whole lot of things that are so unethical when it comes to the principles that we believe are the bedrock of artificial intelligence systems. And there was now this debate of how did it get there? Is it evolving by itself? Is it thinking for itself and coming up with such malicious and such a hostile response to human programming and where the human race is going insofar as data protection and the environment is concerned? And there was a school of thought that said artificial intelligence is actually evolving to a point where it can become hostile, like the whole issue that we saw on iRobot, that movie. And then there was another school of thought saying, no, there is a human being behind all of this who is feeding this adversary, this arbitrary, malicious perception of the artificial intelligence model, which is now coming up as though artificial intelligence is evolving to a point where it is becoming a threat to the human race. So it really shows the importance of ethical considerations and the importance of how the training of the data training data sets that are being used to train the artificial intelligence, and to show the challenge that Abigail was alluding to of how we can control how people will use artificial intelligence models and how someone can influence a bias by the kind of data that they are using to train the models. So yeah, we definitely need regulations. I think initially I used to think that we don't need a regulatory framework that governs how artificial intelligence systems should be programmed and how they should actually be created moving forward. But I'm seeing that this governance issue is going beyond just how people use the systems, but how they are developed, how the systems are developed themselves. What is the design that we are embedding in these models? What is the language that we want them to process? What is the ethical considerations that we should embed in these artificial intelligence models and systems? So we have a challenge on our plate. That is my take on it all. I think it's something that we need to continue engaging in this conversation. Maybe we can come up with a solution.
Just to chime in. So when it comes to the capacity of having sensitive personal data being fed into an ADM system or an AI system, the biggest misconception that I've seen is it uses primary data, or that primary sensitive data, to make inferred decisions beyond the first level of processing. I want you to note first level of processing is an actual thing. And that is the limitation to which you can conduct a DPIA, to which you can have the principles such as minimization and purpose limitation applied to that particular AI system. The main challenge, according to literature, is to what degree can the data sphere actually prevent abuse or misuse or irregularly acquired data to be fed to particular system machine systems. There is currently a pilot program which is being done to create a form of reparations framework or a form of compensation framework for people whose sensitive personal data is being used to train AI systems. Whenever there's a reinforcement learning mechanism in a particular AI system, it is after the first level of training data set is fed. And you do observe, according to the parameter set, there is a bias creep to which a certain particular connotation of bias is prevalent. Majority of ADM systems are fed with data that is particularly stratified and is easily accessible. And then the data scraping tools are what actually keep on scraping the internet for more through it's called a link jump from one link to another. The primary thing that I have seen when it comes to the data protection realm is it is limited because the only impact assessment which is there is on the data alone, collecting it. However, within the development cycle of any AI systems, it can happen on two fronts depending on what legislation exists. One, it can happen on the front of the data which was fed to train that particular model is sufficient because the guidance notes on that particular algorithm or that particular AI system is already out there and it has been tested and the notes have been submitted to a relevant authority. This is what the EU AI Act seems to create under one of its regulations. I can't remember the exact regulation. Additionally, once it's submitted, then it's given the go-ahead for an incubator system, which now you can test it in perfect conditions before it is deployed. 9 times out of 10, most AIs fail. Even when Anthropic were testing their latest model, it seemed that at some juncture, it kept on giving worse results simply because of the foot traffic when it came to now churning results. You could have used their Cloud 4.0, maybe in Kenyan time at 7 p.m., and you found that with each and every prompt that you fed, it got worse and worse. That particular data set, which was used to train it, simply stratifies and breaks down into different task modules, and not every time will you get the right answer. If I relate it to now the principles, it just means when we do reinforcement learning, and I wish we had like a techie on call to even granulate it further. Different levels of training AI will require different data sets, not just biometric, not just personal data. However, be alive to the fact that the reason why some of these tests or some of these impact assessments fail is because synthetic data, which is data generated from these particular AI systems when it comes to training, some of them is not owned by the initial owners of sensitive personal data. Some of them, depending on the legislation that is, will belong to the system in itself. Take a look at Dabus from South Africa, which I believe the courts inferred intellectual property rights on that Dabus AI system for it creating a melamine plate, because it is an original creation of that AI system. And a lot of the data, like people will say big data sets, but if you granulate and break it down, it's down to what particular data set is required. Because don't forget, there's the initial phases of training, the reinforcement to take care of the bias which arises, the retraining again for it to see whether the bias has been cured. And most important is the human in the loop element, which is very important because there's the human before, during the processing, and after. A lot of AI systems become particularly complex when, for example, AI agents, how they make decisions, because it ceases to become more of a decision tree and now leans towards a black box phenomenon, which is complicated to explain and complicated to tabulate or to try and put into words as to how it renders its decisions. Most people will float human rights impact assessments, which is okay, but that's a post-fact redress system. Most people will look at DPIAs, that is a pre-impact assessment. But what about in between? Because there's someone who termed an AI impact assessment as a blanket terminology, which needs to be further granulated and further explained as to why it is necessary for us to have a form of step-by-step impact assessment for us to see what this particular, how these particular principles apply within the processing of this particular data. Because don't forget, there are limitations to the data protection impact assessments, and I'm certain our DPOs would happily tell me world over that this is a limitation. So if I look at that, theory is good when it comes to furthering these principles, but even if the creators of this particular systems which process biometric data cannot explain how it rendered that decision, this black box capacity is what now we have an issue, and that's now where the courts can step in and guide us to inform us on this is the limitation of a particular decision, and if that particular decision cannot, you as a creator cannot explain how it renders that decision, then it is subject to challenge within the jurisdiction of certain courts, within the jurisdiction of, or under the purview of some laws. Thank you.
Thank you, Quincy. You've raised a very interesting and strong point on AI being a black box, such that, yes, we key in the data, we have the input, we get the output, but to explain the technicality or the processes that ran inside that system to give us that output, that is very hard. Now, it being at that level, how do we go ahead and perform risk assessment or impact assessment on these systems?
So currently, the thing with the risk, it's such a broad term because it depends on what framework you're going to use. Majority of people use PCB standards, the ISO standards, but not all of them are relevant to every organization, dependent on size. If, for example, you're onboarding an AI system in, let's say, a banking sector, which has more than 2,000 employees or maybe 30 branches country over, ISO 42001 is very relevant to you because the size and the nature of the organization does require that you have a management system which would apply cross-border. However, it's not as simple and straightforward as this because don't forget there's still a conversation about cross-border data flows, which is very important when it comes to conducting an AIMS or an artificial intelligence management system audit or risk audit. Additionally, when it comes to conducting risk audits, the biggest trouble is expertise because it's not a legal thing, it's not only a DPO thing, it's not only an IT thing or cybersec thing. It involves this cross-functional team in terms of set because the lawyer will be there to interpret the laws outside the purview of the data protection sphere. The DPO will tell you or lock you within the article or within the current regional laws and the local laws. The IT person will definitely follow the PCB standards, which some of them like ISO 38700 are more technical when it comes to AI, and it's not something you can easily interpret as a layman. It needs a technical capacity to understand, even when it comes to now reinforcement learning. That's where they come. In terms of cybersecurity, I'll throw in from this angle. We have a lot of what's it called, quantum processing or quantum issues, which are now plaguing AI systems. By quantum, I don't mean by quantum technologies as the class of technologies. I mean quantum meaning it will use all angles that of probability that you have not factored in when it comes to calculating that particular risk appetite level of onboarding that system. And the moment it does that, you are not sure, even from a cybersecurity issue, whether you can contain and neutralize that particular threat or that particular issue when it arises at that particular time. The reason why I am insistent on this is because we already have case law, particularly within the legal field internationally, which speaks about this. And right now, people are developing quantum AI to break key cryptography standards and levels, which is a whole conversation that people are not ready. So these four actors, loosely put, have some of the most crucial roles there. You will have a similar form of compliance matrix or compliance team when it comes to maybe AI within the education sector, because don't forget, children's data is also sensitive personal data. If you collect children's biometrics and if you feed it into a system, maybe to process school fees, or maybe to put them into a system for maybe capitation, if you're using a blockchain-based system, you will have to figure out how to do that within the limitations of the data protection sphere, which is the principles and the particular rules regarding automated decision-making process and the consent on the consent levels. Within the legal sphere, the Children's Act will step in, and the particular worry right now is even if you get authorizations from the guardians or the institutions which have this children's data, to what degree are you aware or are you alive that their information is being processed for this particular one stage of it being required? Additionally, you will granulate it and look at it, this particular system now when it comes to the IT. Is it a simple decision tree system or a simple AI, or we'll call them narrow AI? Does it fall within this particular bracket? If not, if it falls under an AI agent which uses a black box decision-making process, can I have a glass box remediatory system, which I can see indeed it is subjected to 10 levels of processing, and for these 10 levels of processing, you go back to the DPO and ask them, do I have DPIs for these particular levels or stages of processing? That's why I said there's a limitation when it comes to risk calculation, and this is now where AI elements usually falls under. There's a limitation to this if you solely focus on a standalone DPI for the entire collection of that data. Within these processing levels, there has to be something which, if it comes to audit, or if it comes to now going to court, you can prove beyond a reasonable doubt that indeed you did conduct the procedural checks according to the DPA of the company or the organization, according to the lawyer within the in-house counsel, within the IT, and within the cybersec teams. If you can bracket all that, you can have a form of granulated thing, a granulated compliance matrix. Don't forget, and I say this loosely, just because we don't have a central regulator within the African sphere context doesn't mean that we can't co-create one which falls in. Because there are people right now within the AI sphere focusing on the data and monetization, some are focusing on the processing, some are focusing on the creation, some are focusing on the testing phases, which is the incubator systems. Some are focusing on building simple systems that will actually help explain this particular AI and what it does. This just tells you that the compliance team or the risk assessment team that's going to be there is going to have such a huge task to create this and to find like a, let's call it a regulatory checklist or a compliance checklist in this case. A good chunk of it, there are two banks which I'm working with, one in Nigeria, one in Kenya, and we have developed a very good checklist for this particular compliance. And each and every time, depending on the size of the organization, you will find that you can have a lot of risk embedded within onboarding that system, and it just increases, like it reduces investor confidence. Because don't forget, if you onboard an AI system into your organization and it does not particularly become a tool, but it becomes a compliance nightmare, and it interferes with the business model which you're profiling, creating more barriers, then there's no need for you to onboard it yet. You'd rather stick to the old systems until you can justify, especially when it comes to the board and when it comes to the administrative functions of these particular organizations, that indeed onboarding this will have a form of efficiency, will reduce costs, and have all these textbook benefits that usually there. If you can't justify that, then the question that I ask normally all organizations that I train is, how much risk appetite are you allowed to have when you're onboarding an AI system, whether it processes biometric, children data, or any form of other SPVs within the organization, without making it a hurdle to your business model? That's how I look at it right now. Thank you.
Thank you, Kwesi. There's a question from Kega saying, kindly restate the standard that apply in the realm of AI.
I will avail all of them. There are about 9 PCB standards, but PCB is not the only standard which you can use. There's a webinar which I'll conduct after this. I don't want to market it here, but there are webinars which we do conduct sensitization initially, and then now when you come to now specialized how to do it or how to onboard and how to comply. Now there's now we train people, particularly I do it with the Paradigm Synergies Enterprises.
Okay, thank you. Pavro, do you have a point to add on that?
No, I think Quincy has really cut it down sufficiently. The only thing that I just wanted to add on was from the context of the European Union, because they now have an AI Act, which was enacted last year, 2024. And it actually sets out some of the things that Quincy was alluding to. And in one of the articles, the Act prohibits AI systems that deploy subliminal or purposefully manipulative or deceptive techniques with the objective or effect of materially distorting behavior in a manner which causes significant harm. So obviously this also touches on data protection issues. It also speaks to how AI systems should deploy or rather how they are prohibited from processing biometric identification in a manner that is harmful to the rights of data subjects. So I think we can, from the African context, we can try and learn from this piece of legislation and come up with frameworks that can speak to the proper deployment and use of artificial intelligence systems.
Rufaro, you've talked about learning from what has been happening globally. Abigail, I'll give this to you. Is Africa, what can we, or what are the lessons that we can learn from the cases that has been heard from other countries in relation to AI?
Like what I was saying, from a legislative framework perspective, and also from an implementation perspective. For example, when we see the different cases that have come up in other jurisdictions and the fines. For example, we've got a case, it's Clearview case, where there was a lot of infringements of data protection infringements, and Clearview had breached a lot of those, and they were fined. They were given a hefty fine, like it was 30 million pounds, and that's a lot of money. I'm saying we can learn from this because if I juxtapose it with my own jurisdiction, I'm an attorney practicing in Zimbabwe, Harare, and our piece of legislation that speaks to data protection, our Cyber and Data Protection Act, the fines that currently provided for there in the penal provisions where there's a data breach or there's violation of data compliance issues is a level 14 fine. And when we look at the schedule that provides for how much that is in Zimbabwe, that's like 5,000 US dollars. So as compared to a 30 million euro or 30 million pound fine, that is different. That's really significant. That is a significant difference, and we can learn from that. So our DPA, Portras, was actually speaking at one of the conferences that I attended, and their representative was actually saying that they are reviewing the administrative fines that they can impose if there is a breach or there is non-compliance or there is a violation of our act. So that is one of the examples that I can give in what we can learn from other jurisdictions when it comes to compliance issues and fines that we have seen in other jurisdictions, because this particular case is a very good example of what a jurisdiction or what a court of law needs to consider and what a court of law can actually impose as a fine where there's been a breach. So the key violations by Clearview involved unlawful processing of data because their AI system was collecting and processing biometric data without a valid legal basis, and they were violating Article 6 of the GDPR. So this is one of the examples. It's a whole long list. They even breached Articles 12, 13, and 14 of the GDPR. There was lack of transparency, and it's a long list, really. So that in itself shows how us as a continent, we can learn from those jurisdictions, what we can do, how we can address these issues, how we can use even our existing laws on data protection to govern the use of artificial intelligence systems in our space before we then get those regulative frameworks in place whilst we work on them rather.
Abigail, I believe you have something to add on the lessons that we've learned or we can learn.
Yeah, I think Rufalo and Quincy have done a great job. I think I've written quite a bit. I think the only thing I would add simply as well is just that when it comes to data protection and data privacy, especially in the AI space, and we're learning from other jurisdictions, the thing to also remember is that it's not just about the wallets. It's not just about the money. If you look at European backlash to how facial recognition misuse damages reputation to organizations and companies and such, then I think it's important for us as well here in Africa, where we're trying to build our digital environments, our digital landscape, to be able to make sure we learn from that so that then organizations maintain trust with the public, as well as much as this is all about compliance and what at the base of it is the data subject and maintaining trust with the data subject. And so I think one of the things we could learn from other jurisdictions as well is just that the strength at which they put these safeguards and the strength at which they're using they're fining organizations for not complying, for going against the GDPR and such, then I think it's also important for us who are building our digital landscape. We're trying to digitize everything. We are creating, Silicon Valleys and such. I think it's important for organizations to make sure that and companies to make sure that they maintain their trust with the data subjects in this digital economy and digital landscape, because then it could stall growth in its entirety. And I think that's the only thing I would add for that part.
Quincy?
Having delved like into both fields, I don't know. I think I concur with what she proffers. It's just that like trying to lock it down into biometric systems, there's a way I'm conflicted, particularly when it comes to like what's already there in terms of law and what's there in terms of what happens. We usually say ground vision is different. I don't know. Could you further explain that a bit?
Quincy, sorry, the question is directed to me or Abigail.
Abigail.
Okay.
Oh, sorry. Come again.
Like, could you clarify like your question just a bit so that I have narrow focus on what to particularly tackle within that what you've said?
Oh, on compliance. So we were talking about compliance and it being about trust and
Yes.
learning from other jurisdictions, looking at how they fine, and it's not only about just the wallets and the fines, but again maintaining trust with the data subjects, with the organizations, and so that we're trying to build the tech in our country. We're trying to put in policies and regulations and such to support the growth of technology and such. And so if there's a mistrust, if there's a reputational damage, if we don't have trust in the authorities, then that stalls growth.
Okay. So let me play devil's advocate here, pun intended. So out of quite the number of case law I've interacted with, or the number of participants I've interacted, there's always one question which I ask: do you use ChatGPT? Yes. Do you care that if you ask ChatGPT, can you predict my future? It gives you an accurate deposition of who you are according to the data it's scraped about you. And truth be told, as much as data subjects are like the trust needs to be maintained, is to what degree do data subjects actually care that their data is being fed into this particular system? Because if you have a consensus where you have let's say out of a population of 1 million people, you have 600,000 people who are concerned about their data being used to train AI models, then that raises a concern. A lot of people usually oppose these systems because they're not getting any benefit, or they're not deriving benefit, which is always follow the money. It's always on our financial capacity, sadly to say. Until a particular bias becomes outright and it becomes apparent, and it creates a significant change in people's behaviorism and mannerisms, then a lot of tests or a lot of outcomes are usually rubbished off by the end user. It's the authority, or rather the regulatory authority's duty to do CSR and to conduct as much as possible tests as to how it's affecting societal outcomes. If you look at State versus Loomis, the bench had so many varied opinions, and one of the judges within that particular decision did render that if the particular data subjects do not see that indeed they are aggrieved by the automated system, then it is indeed the court's purview that there is no infringement on their rights and there's no form of bias or profiling in this case. However, it is one judge who had a differing opinion, and they stated clearly that even though the masses are ignorant of the manipulation of the profiling that's happening in these automated systems, it is the purview of the higher authority or the regulatory authority to educate, roll out safeguards, reporting mechanisms, and additionally to do damage control when it comes to these particular systems. If, for example, the reputation between a certain company and a certain AI company and the public masses causes an outrage, then it is also the obligation of the regulating authority to also come out with ways of correcting that particular harm. Sometimes it's compliance, meaning once you comply, then you're set. Sometimes it's more retributive, meaning you'll have to either decommission that particular platform or software. And this is now where the ICT law steps in, like what type of contract are you setting? Like there's so much. If you granulate that particular problem, you'll see that reputation, hands down, but to what degree or what extent that the masses actually care that the data is being used. You can see this. You can ask anybody, even within this call, how many people have prompted ChatGPT to tell you, what do you predict about my future? Stemming out of the collected data that it has gathered from you prompting it over the last few years, and the result, a lot of people don't mind this. And if, for example, you lodge a complaint in maybe the appropriate forum and they have the appropriate regulation, this particular data subject will either seek restitution in form of monetary compensation, or they will not care at all, because that's essentially what I've seen. Because if, for example, the Data Protection Commission of Kenya, if they were given powers to listen and determine on matters related to automated decision-making process beyond the fourth degree of processing, then you'll find that a lot of data subjects who file these complaints will adequately accept the monetary compensation which they'll be awarded within the final particular rendering of the final decisions. That's the current trend that I've seen in most regulatory bits. And you can see this even it's called OpenAI versus New York Times. It's always monetary compensation, because if you can improve the livelihood of someone beyond what they're using currently, usually which is monetary, then satisfaction will be there. And this just stems from psychology. Read Predictably Rational, chapter 3 on rationality beyond beyond resources constraints. Like you get to piece and see like why data subject relationship usually is more weighted on the data subject accepting that indeed they have an infringed right, rather than the regulator telling them, oh, your rights have been infringed. And then it will bring the conversation on human rights, whether the human rights impact assessments within the automated sphere are actually considered in the design, whether we have a form of data protection impact, which links to the human rights impact, which links to the decisions. Like it's a whole cog and wheel mechanism. And if you want to really lean on that textbook definition or textbook answer on the relationship, then that is perhaps one side of the coin. Yeah, thank you.
Just to respond, I agree with you. I think I agree in the sense that it's one side of the coin. I agree that the courts or the authorities are the ones who are not going to start explaining to people. But I think also similarly, the way you said, kwa ground vitu ni different. One thing I've seen is even ourselves, by the time we got people to understand what a privacy policy is, all apps people are reading, people don't understand them. And that means they will never know that their rights have been infringed. But then you see that as well when cases come out and, oh, we lose trust in this organization. If it was nation media and posting pictures of people in clubs or schools, the more these things come out, then the more you say, oh, that club we will not go to, or that restaurant we will not go to. But I think at the base of it as well is just the knowledge. If people don't know and they don't understand what this is, for us it seems a bit simple, simply like a privacy notice. It seems simple because it's just telling people, okay, what personal data is being collected, how it's being used, etc. It seems simple until you explain to somebody else and now they get it. Now they have, and so that they have more responsibility. They feel they can do something. So I agree there's the monetary part of it as well, but I also think kwa ground different. For those who maybe not understand English, we mean that, so those who may not be understanding Swahili, we mean that on the ground, things are different. A lot of it is just knowledge of the data subjects. We need to, and I think maybe that's why it's important to keep having the training and awareness and such things like what we're doing today. Yeah.
Thank you. Queens.
Go ahead.
I'll read a chat from Florida, Musi. She's saying, as we continue to embrace digital technologies and open our markets to foreign investors, a pressing question arises. How can we, at the same time, achieve digital sovereignty? And she goes ahead and states, in many African nations, the challenge is compounded by the reality that we are often playing catch up in terms of technology, expertise, and infrastructure. This dynamic tends to create a dependency on external actors, many of whom draw investment end up controlling significant volume of our data and digital systems. Achieving digital sovereignty in these contexts requires intentional efforts to build local capacity, establish strong data governance frameworks, and ensure that investment agreements prioritize local ownership, accountability, and long-term technological independence. I believe that is in response to what we've learned or what we can put in place to make sure that we are at a better state. Thank you, Abigail. Thank you, Quincy. Thank you, Rufara. It's and every one of you has talked on AI implementation in our organizations. We've talked on of the lessons that we've learned. Now we'll go to the next point of discussion. Having listed or having given out the risks that our organization could face in relation to their clients' data, now, what strategies can organizations put in place to make sure that they are ready for the risks that might arise? I'll start with Abigail.
Okay. So simply some of the things maybe that organizations can do as they prepare for some of the risks would be, the first things first is identify what risks you might come across. Very early on, if you're going to be handling, for example, sensitive data, biometric data, you need to be aware of what risks you might come across. And that means then you'll be able to manage them. By risks, ask yourself what could go wrong. if that biometric data got into the wrong hands, was misused, what could go wrong for your organization, what could go wrong for the data subject. So I think one of the first things to do is identify the risks. The other thing is identify what personal data you have and what you're using it for. Basically, we're talking about your data mapping, your records of processing activities. Have an accurate idea of, in your privacy program, have an accurate representation records of the personal data that is in your organization, how it's moving, who it's being shared to, are there other entities it's being shared to, what your purposes for processing are for each. If you have multiple purposes, they all have to be recorded as well. What your legal bases are for that processing. If you're relying on consent, for example, for biometric data, that also needs to be recorded in your records of processing activities. Again, also with those processing activities, you have the security measures that you have put in place as of now. You can still update it as you go. So some of these security measures that you'll have put in place, are you also transferring personal data out of the organization, out of the country? Are there standard, the adequacy measures, the standard contractual clauses, binding corporate rules? These are just the measures that you have to put in place and that you look at, or the regulations that you look at when you want to transfer data. So when you're looking at your privacy program and making sure you're ready, first of all, just make sure you know what personal data is in your hands, what you collect, what you use, what you store. Then you're also going to look at your documentation. Do you have your privacy policies, your privacy notices, your consent forms? Are they regularly updated? If they haven't been, who is in charge? Do you also have your IT policies, your acceptable use policies? So a lot of your documentation as well, your retention policies, are they up to date? Keep them well and keep them updated. You also have your DPIAs, where you're processing sensitive information or any information that's likely to cause high risk to data subjects. Do you have a record of that? Regularly update your DPIA for your processing activities. We always say that a DPIA is I like to say it's a living document that you come back to. If you find that your processing has changed, you come back to it. When there's a new technology, new AI system, you're with a certain processing activity, then you can come back to it, do a DPA, but keep those records in check. The other thing is your incident and your breach plans. As an organization, that's a thing you cannot not have. Because the thing I also like to say, another saying is that when it comes to incidences and breaches, it's not a case of if, it's going to be a case of when it's going to happen. So will you be ready? Remember at the beginning I said we're going to identify the risks that your organization will be having in these processing activities. And so then that means then with your breach and incident plans, you're also prepared to deal with them when they come. Do you have who is going to be in charge? What are the notification procedures? Do you have deletion? Do you have shutdown measures? How do the other departments in your organization run when there's an incident or a breach? Who do we consult when it comes to communication? The IT team and the what are they called? Sorry, the computers, for example, that you're using, or the systems that you're using. What are the duties of each person in the organization when it comes to the breach and incident management? The other thing also is access requests. Like I said, data subject is at the center of all this. So do you have mechanisms so that data subjects can exercise their rights? If they want to have their data corrected, if they want to have their data deleted, if they want more information, they want to access. Remember, like we said, even with new tech and with AI is the explainability and transparency. The transparency principle, together with the data subject's right to information, you need to be able to have those mechanisms in place in your organization as you prepare for this. Yeah.
Thank you, Abigail. I believe Rufaro has something to add on to that.
She's done a great job at that. The only thing that I would add on is to just make sure that, well, I don't know if in Kenya you've got the same thing, but it might be similar, that in Zimbabwe, we are required by law to have a certified data protection officer. I know in Kenya it is just an ordinary data protection officer, I believe. Ours then went an extra mile to say it has to be a certified one, but well, that's not my point. My point being, it means that when you're doing your strategies, your DPO must also be engaged with the stakeholders and be conversant of what is required from a compliance perspective insofar as engagement with stakeholders is concerned. I'll just give an example. In our jurisdiction, if something happens, the DPO already knows that they're supposed to inform the DPA of an incident, and depending on the level of risk that the personal information is posed at, then the data subjects whose data has been exposed must be notified. So all of those things in your strategy, you must be conversant of all of those things as an organization and not wait upon the DPO to be the one to know that this is what is required. Because if the DPO is not in-house, then you might actually miss out on the 24-hour notice. For example, in our jurisdiction, we have to give we have got a 24-hour notice to notify the DPA. So if the organization does not know all of these compliance issues, then it becomes a problem, because you cannot wait for the DPO to then come on site and then notice that there is a breach and now they have to notify. So it speaks to training of the staff of the organization as well. So in your strategy, one of the things that must be there is training of the staff and training of the key people that you are putting in place as the people who are going to be responsible when there's an incident, for example. So I think training has to be part of the strategies as well.
Thank you, Rufaro. I remember, Abigail, you had also talked on awareness training and making sure that our users are aware on how their data is being used. Quincy, do you have an additional point?
No, they have summed it up really well. Actually now I want Abigail to now train me into this mitigation risks now. Thank you.
Yes,
Yes,
I have
please.
a whole list. Yes. Okay, we are winding up. I can see we are running out of time. For our audience, in case you have a question, put it on the chat. Karimi, at some point, I saw that you had raised your hand. Was it a question? Okay, as we wait for the response, we can now give our final remarks on the topic of discussion today so that we can wind up our webinar. We can start with Rufaro.
Okay, thank you, Dominica. I thank you so much. I've learned so much from Quincy and Abigail. I've got a lot of take homes for myself for the future. So as a closing remark, I'm seeing that indeed data protection in the context of biometric systems, biometric information, and the use of artificial intelligence is a challenge for everyone, every jurisdiction. And I see that the most important thing for us to do is to ensure that there is harmonization of legal frameworks. I'm happy to note that from the African Union, we have a document that they did on artificial intelligence that we can all actually learn from, that we can adopt as a continent and probably implement insofar as our frameworks is concerned, and try and incorporate in our pieces of legislation. And I think together we can assist each other on how to deal with the issues of artificial intelligence so far as privacy concerns is concerned. And it will also be good for us to borrow from other jurisdictions, particularly as we have already noted that best practices are coming from countries like, the European Union, pardon me, the European Union, and even what is happening in the States. I see California has got a case law that has come out that can also assist us in how we can navigate issues pertaining to privacy insofar as biometric information is concerned.
Thank you so much, Rufaro. Abigail?
Yeah, I should be unmuted. For me, I think my closing remarks, learning from Quincy and Rufaro. I think from Quincy, I'm very inspired to get into the techie side of it. I think as much as I talk about training and awareness and data subject learning, it's also important, like I said, engaging with stakeholders. And for me, that as at the lowest level is learning from each other. And so as much as you can stay updated, stay learning. There's a point about SMEs and small businesses in this big world of tech and AI, new technologies, biometric data, then how then do we bring it down to a level that's not as it's not as large and not as overwhelming. And I think one of the things I've seen is just keep talking about it, keep learning from each other. A lot of the things I've also learned from Rufaro, with the legislation, with the different legislations and case laws that have come up. The more you know, the better it is for you. The more you are aware of mitigation measures you can put in, risk measures you can put in. You can hear from other organizations as well. If they say, for us, we've decided we're not going to go and use, for example, an SME, we're not going to go and use a free AI tool just because of the risks. There's this other one. So I think some of these things just involve a lot of discussions like these ones and learning from each other. And when it comes to AI and biometrics, as of now and where I am at with it, I'm very insistent and specific to data protection impact assessments. There's an impact, I think, Quincy, you mentioned in your assessment. I think you clarify for me. There's an assessment you talked about during the in the stages of the AI, somewhere in between. Then it's not a DPIA, but I think from where I sit, I've seen the impact of having DPIAs regularly, because in as much as it's an assessment, one of the hidden advantages of DPAs is they kind of act like a record of processing, because the information you're capturing there is the processing, the personal data, where it moves, if it's being shared, the security measures, the third parties involved. And then after that is when we do our risk assessment. And so in a sense, then it at the lowest level, even for an SME, for small businesses, small organizations, data protection impact assessments sometimes can be your first line of defense. Other than just reading and engaging with other businesses and stakeholders, staying updated, a data protection impact assessment is, when tech is changing, it helps you stay updated, and it helps you manage the risks that are going to come with processing this personal data using AI, or if you're using biometric data, in particularly in the field that you're in. And I think my other last remark when it comes to AI and biometric data is, yes, it is sensitive. It's not a no, but it's a learning point. We can learn from it. Yeah.
My turn.
Yes.
So thank you. I do enjoy having these conversations. I think I've picked up from Abigail that I really need to learn from a DPO who's much more experienced. That is for my future consultancies, which I'll share with the world in a couple of months. The one thing I've picked up is you have to have processes and you have to know each and every step well. From Rufaro, from Abigail. And it's good that along my journey of learning and reading, I do get to interact with industry leaders and people who are, as you said, quite different in the dais, who have practiced and know what actually happens in terms of compliance. I would be more than happy to actually shadow someone within their DPO processes, maybe like a week, to find out what they do, because in government we do have quite a number of bottlenecks when it comes to compliance. To answer Abigail, so at the beginning of the development phase, do a DPA on the data. Within the life cycle of incubation testing, do an algorithmic impact assessment. At the end of it, do a human rights impact assessment. There are no formal frameworks for the AIA. I wrote it as my master's thesis on how to integrate it into the Data Protection Act, because I think it's very important. I can share it with you post fact. Then additionally, you could have an overall impact assessment now, which you call AIA, artificial intelligence impact assessment, AIIA. The current framework is within the, check the Hiroshima process. You'll find it, it's etched there somewhere. My parting shot is we are here to learn. I do enjoy learning from other people because it shortens my grasp of having to go read volume 10 books and other big books. It's usually very refreshing to get divergent perspectives and to have we call it tete-a-tete, where now we exchange ideas and we tend to break down how people see things. For anyone who wants to join me in this journey of writing and in this journey of learning, my LinkedIn is always open. Hit me up. There are a couple of trainings which I'm doing beyond the fact. I would love for everyone to join, but the next one is kind of more in the boardroom level, which starts on Monday. Then after that, now I am targeting particularly DPOs, because there's current conflict within everybody wanting to be an AI policy analyst or AI policy expert. That's not the only role that's there. There's so many things. If there's an organization that wants to be trained on AI governance, I'm here. My consultancy goes up in September, personal consultancy, because there's a lot to teach and there's a lot to learn. I would say be curious, read widely, and then form your own questions, because not everybody will think for you on your feet. The same way I got to learn about DPI is the way I got to learn about AI is through curiosity and also participating in a lot of talks. So I encourage anyone. If you're from Uganda, there's a friend of mine called Simon Higwenyi. I have managed to mentor him to the point now where he's leading university conversations when it comes to AI, and I love what he's doing. The future is bright, particularly when it comes to AI and data. Be the leading voice within your particular sphere. There's always a room for someone. So let no one cast doubts on what you're trying to build as an individual in this field. And always make sure there's always room to ask someone who's more experienced to teach you or to show you what they did when they face a certain hurdle or challenge. So go forth and conquer. Thank you, everyone.
Thank you so much, our panelists, for availing yourself in educating us. I believe I talk on behalf of everyone all the audience that we've learned a lot, and I can only hope that we'll go and apply what we've learned. Yes, not unless someone has a question.
Oh, for the Kiga, I've seen you followed me on LinkedIn. I'll share the PCB framework for you so that you can know which one is actually relevant for every organization. And then you can, if you can access the PCB standards, then it's good for you to understand like what each one of those, there are about 6 standards mean and which one is relevant to you.
Okay, no, anyone with a question? Kiga says, thank you. Abigail has shared her LinkedIn profile. Let's go and follow and engage. Please, Quincy and Rufaro, make sure to share your LinkedIn profile link.
I can't seem to paste mine. I don't know what's happening. Maybe just my name, Quincy Atieno, you'll find it there because I'm trying to paste it.
Okay, I've done that for you. Let me get Rufaro.
Okay, thank you. I'm also failing to get my, but it's just Rufaro Mando. If you
yes,
look for
Melissa,
me,
it's called Simon.
it will be.
Oh, apologies, I'm answering off the chat. Melissa, hit me up on LinkedIn so that I share his profile.
I've also shared Rufaro's link. Thank you, our panelists. Thank you, our audience, for joining this webinar. Have a good day.
Thank you as well.
Thank you so much.